There is a grim irony at the center of Cornell's latest campus controversy. Students were protesting what they saw as the university's use of disciplinary machinery to punish political expression, especially pro-Palestinian protest. Then, when they confronted the university president with questions, the administration responded by casting the encounter as intimidation, harassment, and disorder. In other words, students objected to a system that converts dissent into misconduct, investigates that misconduct without constitutional protection, and then hands its files over to criminal authorities for punishment. The system answered by converting their dissent into misconduct. That is not an accident, it is the pattern. The recent parking lot incident involving Cornell President Michael Kotlikoff did not emerge from nowhere. It arose from a broader conflict over how the university treats protest, discipline, immigration vulnerability, and the boundary between campus procedure and state power. The public discussion has narrowed too quickly into a familiar question. Did the students go too far? But that question is incomplete. The more urgent question is why Cornell has built and continues to defend a disciplinary apparatus that can function as prosecutor, judge, investigator, record keeper, and political actor all at once. The answer should disturb everyone, including those who disagree with the protesters' cause. At the precipitating event, students confronted President Kotlikoff after a campus debate connected to Israel and Palestine. According to the president's account, the students harassed him, intimidated him, surrounded his car, blocked him, shouted, and banged on windows. According to student accounts and press reporting on video of the event, the encounter looked different. Students questioned him, filmed him, stood near the vehicle, and then the vehicle reversed into at least one person, with another claiming his foot was run over. Those facts are still being interpreted. That is precisely the point. In a legitimate system, disputed facts are handled carefully, independently, and with procedural restraint. But in the university setting, the institution itself often controls the first official narrative. Once the administration labels an event harassment or intimidation, the disciplinary, criminal, media, and donor-facing consequences begin to align around that framing. This is how repression works in modern bureaucratic form. It does not always arrive as a baton. Sometimes it arrives as an email from the president, a conduct code notice, an interim suspension, a mandatory interview, a threat of expulsion, a referral to police, or a file that can later be subpoenaed. The old police backroom extracted confessions through physical abuse, but the modern campus version performs the same role through administrative coercion. The student is told, participate in this internal process or risk suspension, expulsion, loss of housing, loss of funding, loss of visa status, and perhaps the end of your academic future. Speak, and your words may later be compared against video, chat logs, social media posts, police reports, and the statements of other students. Stay silent, and the university may treat that silence as non-cooperation. That is not justice, it is coercion laundered through procedure. The deeper scandal is not only the parking lot incident, it is what the incident reveals about the university's power structure. Cornell is not merely an educational institution in these cases. It is the complainant, the investigator, the adjudicator, the custodian of evidence, the disciplinary authority, the public relations actor, the visa-sponsoring institution for international students, and the entity most invested in protecting its own reputation. When the president himself is implicated in the underlying facts, that conflict becomes impossible to ignore. No serious conception of due process can tolerate that many roles being collapsed into one institution. Consider the earlier disciplinary actions that provoked student outrage in the first place. Students have objected to university discipline for protest activity, including suspensions and proceedings imposed before meaningful findings of fact. For domestic students, that may mean academic disruption, stigma, financial harm, or exclusion from campus life. For international students, the stakes can be catastrophic. A suspension can threaten visa status, a disciplinary label can become an immigration risk, a university record can become a state or federal enforcement tool. This is where the constitutional outrage becomes unavoidable. Formally, the university can say that it is not punishing speech, only conduct. But protest almost always occupies the contested line between speech and conduct. Marching is conduct. Chanting is conduct. Recording is conduct. Occupying space is conduct. Following a public official to ask questions is conduct. The administrative trick is to strip expressive activity of its political context and redescribe it as disruption, intimidation, obstruction, or harassment. Once that transformation occurs, the First Amendment is honored in theory and hollowed out in practice. The campus tells students they are free to speak, provided their speech does not become disruptive. Then it defines disruption broadly enough to include the forms of protest most likely to matter. It tells students they have a process, then makes that process perilous to navigate. It tells students they have rights, then places them in a disciplinary setting where asserting those rights may be punished as defiance. It tells students that police and immigration consequences are separate while generating the very records that outside authorities may later seek. That is the end run. The university need not be the police to serve a police function. It need not be ICE to create immigration exposure. It need not be a court to impose court-like penalties. It need only build an alternative adjudicatory system that produces official narratives, compelled statements, investigative files, and life-altering sanctions. This should alarm the public because it is not limited to one ideology, one protest movement, or even just one campus. The machinery being used today against pro-Palestinian protesters can be used tomorrow against labor organizers, anti-war activists, racial justice protesters, conservative dissenters, whistleblowers, or any student movement that embarrasses the institution at the wrong political moment. History is full of institutions that insisted they were merely preserving order while suppressing dissent. Southern universities disciplined civil rights protesters for disruption. Anti-war protesters were described as threats to campus safety before they were recognized as participants in a moral struggle over state violence. McCarthy-era institutions punished association and political speech while claiming to defend national security. The language changes, but the structure is familiar. Authority defines dissent as disorder, then punishes the disorder it has defined. Cornell has now placed itself squarely in that lineage. To be clear, no one has a constitutional right to threaten another person, physically block a vehicle, assault someone, or create a genuine safety hazard. If students commit crimes, the answer is not impunity, the answer is court. Real court, public court. A court with rules of evidence, counsel, subpoenas available to both sides, suppression doctrines, constitutional constraints, an independent judge, and the burden of proof placed where it belongs. The answer is not a campus tribunal operating under institutional pressure, reputational panic, donor anxiety, congressional scrutiny, police interest, and administrative self-protection. That distinction matters. If conduct is serious enough to be treated as criminal, then it should be handled by the criminal justice system with all the constitutional protections that system is supposed to provide. If it is not serious enough for court, then universities should stop using quasi-criminal processes to impose quasi-criminal punishments while avoiding the safeguards of actual law. The existence of university disciplinary systems for academic integrity, classroom misconduct, residence life conflicts, and ordinary institutional governance is one thing. But when alleged misconduct overlaps with crimes such as assault, obstruction, harassment, trespass, vandalism, unlawful imprisonment, or reckless endangerment, universities should not be running shadow prosecutions. They should not be compelling students to create statements that may later be used by police. They should not be conducting parallel investigations that blur the line between education and prosecution. They should not be imposing life-altering penalties through processes that lack the legitimacy of courts. The public has been trained to think of campus discipline as softer than criminal law. In many cases, it is not. It can be faster, less transparent, less accountable, and more coercive. It can impose punishment before facts are settled. It can destroy immigration status without a conviction. It can produce records without constitutional safeguards. It can punish silence. It can make students choose between defending themselves academically and protecting themselves legally. That is not a gentler alternative to justice. It is the subversion of justice itself. The parking lot incident crystallizes the danger. If students intentionally blocked a vehicle, that fact can be evaluated under actual law. If the president drove recklessly into students or left after knowing someone was injured, that too can be evaluated under actual law. But what cannot be legitimate is for the university to control the narrative, discipline the protesters, protect its president, generate records, and then allow those records to migrate into criminal or immigration channels. A system cannot be legitimate when the institution under scrutiny also controls the machinery of judgment. Cornell's student community should therefore resist the temptation to treat this as only a dispute about one president, one protest, or one video. The issue is larger. The issue is whether universities will continue to operate alternative adjudicatory systems for alleged criminal misconduct while avoiding the constitutional limits imposed on actual prosecutors and police. They should not. If a student is accused of a crime, send the matter to court. If the evidence is insufficient for court, do not launder the accusation through a campus tribunal. If the university wants to protect safety, it may take narrow, temporary, non-punitive measures to prevent immediate harm. But it should not run parallel prosecutions. It should not force students to choose between academic survival and self-incrimination. It should not create files for the state while pretending to be merely educational. Abolish these alternative adjudicatory systems for alleged criminal misconduct. Restore the line between education and prosecution. Restore the presumption of innocence. Restore the right to silence. Restore independent adjudication. Restore the principle that serious accusations belong in legitimate courts, not institutional backrooms with better letterhead. Because when a university can punish protest, compel explanation, generate evidence, invite state power, and then call the whole thing process, the danger is not merely that some students will be treated unfairly. The danger is that the university has built a machine for making dissent criminal.